Mhm. Hi everyone, Rafaela and I are very happy to share with this Global Center the panorama of climate litigation in Brazil and how the Brazilian justice system is helping in a just transition. I am Luciana Bauer and I was federal judge for more than 20 years, and Rafaela is still a federal judge in Brazil. We conducted research at Unisinos University, Univali University, and Widener and Berkeley University on climate law and its impact on public policies, especially in Brazil's judiciary. Starting your lecture, we'll present the climate litigation in Brazil and the contours that the Brazilian Constitutional Court is giving to the issue in what we call the Brazilian Constitutional Green Agenda. The climate litigation in Brazil is centered on the protection of human rights, and the Supreme Court is ready to define Brazil as an ecological democracy. The climate litigation, especially since 2020, has increased in the number of cases. In Brazilian justice, we have a platform of official climate case managed by Rafaela on the page of the National Council of Justice that is scaled Just Clima. There are the official data in Portuguese and English. Well, since 2020, these cases have increased and are related to human rights, including the rights to life and to an ecological balanced environmental, and other fundamental rights, such as rights of indigenous people and traditional communities. There are a strong connection between environmental and climate change matters in Brazil in a central aspect. We know that the climate litigation movement in Brazil is rich in environmental theory, a construction of strong environmental law that we have for 30 years in the courts. Brazil Constitution recognizes the right to an ecologically balanced environment. We have a hybrid system of constitutionality control here in Brazil that mixes European style and common law. Brazilian has a green amendment in the federal constitution, the famous Article 225. And we have a chapter in the Brazilian constitution dedicated to the right to an ecologically balanced environment. The right to an ecological balanced environment is essential to secure a healthy quality of life. This approach is also evident in recent case. The Brazilian Supreme Court has consistently invoked general principles of environmental law to guide the decisions. Principles such as the precautionary principle, prevention principle, and polluter pay principle have been cited to underscore the importance of environmental protection and the states of duty. The Brazilian Supreme Court also emphasizes the importance the international treaties and agreements in shaping domestic environmental law and policies. And just like the Dutch court in the agenda action, the Brazilian Supreme Court accepts that the environmental protection is not a matter of political choice, but a constitutional duty. The Brazilian Supreme Court has emphasized that the executive branch has a legal obligation to make measures to protect the environmental and combat climate change. This reaffirmation of the state of duty to environmental protection has significant implications for policy and governance. The Supreme Court also identified in this climate case that there in an unconstitutional state of affairs and environmental matters. The Brazilian Supreme Court has used the concept of an unconstitutional state of affairs to describe situations where there are systemic violations of fundamental rights and failures in the implementation of environmental policies. In the decision of the Supreme Court, we can see very clearly the principle of separation of powers and an affirmation of the role of the court's judicial review. The Supreme Court has clarified its role in reviewing executive actions related to environmental protection and climate change. The Supreme Court has increased the use of scientific data. The STF has recognized the importance of scientific data and evidence in addressing environmental issues. The court has relied on scientific research. Now let's move to the analysis of the most important case in the Brazilian Supreme Court. We call the climate case. We so-called spring agenda comprised 7 cases related to environmental protections and sustainable development in Brazil. 3 of these cases are climate actions. These cases are the Fundamental Rights Direction Actions, IDPF 708, the IDPF 760, and Declaratory Action of Inconstitutionality by Omission, IDO 59. In this case, the initial petition and the votes refer to climate impacts according to the IPCC reports, the Paris Agreement, and are also associated with the Sustainable Development Goals in the 23rd Agenda. Most Brazilian climate litigations, and especially the Constitutional Green Agenda, represents cases related to deforestation and the deterioration of key biomes from Brazil. In this perspective, the most significant case in this on vote on the courts is the ADPF 760, which address the plan of action for the prevention of control of deforestation in the Amazonia. The petitioners in this case call for compliance with national policy and climate change in order to achieve the climate target of a maximum or minimum amount of deforestation in the Amazon. The petitioners also point to serious violations of the fundamental rights of indigenous people and traditional communities, beyond the needs to preserve the rights to present and future generations. Justice Carmen Lucia presents her opinion to order that the Union and relevant federal agencies present a specific plan within 60 days, which must contemplate a summary of activities that might control environmental inspection and combat crimes in the ecosystem, while safeguarding the rights of indigenous people. It concludes by the existence of an unconstitutional state of affairs, demanding urgent action to protect fundamental rights related to the environment. Another action is the ADPF 708. In the case, the plaintiff, the SOL party, and the Socialist Party, a political parties, argue that the Federal Union violated the Commissive and Omissive Acts through proper functioning the National Fund of Climate Change, the Climate Fund, violating the right of all Brazilians to a healthy environment. The court agreed with the opinion by Justice Fachin and Barroso that the um, executive and the constitutional protection and duty protection of the environmental, of the international rights and commitments assumed by a well is the constitutional principle of separation of powers. The court, by majority, established the following judgment thesis. The executive branch has a constitutional duty to operate and annually allocate the resource of the climate fund for the proposed and mitigating climate change. Ban in contingencies prohibit to the constitutional duty to protect the environment, the Article 2025 of the Brazilian Constitution. Justice understand in this case that the climate rule is direct at first to the maintenance of a stable climate system, but above all, the maintenance of life and future generations. Justice Edson Fachin and Roberto Barroso issues their opinions in the sense of the recognizing the existence of a climate rule of constitutional background. For the justice, the climate crisis is urgent and non-negotiable, demanding immediate action. Another important action is the ADO 59. The Brazilian Constitutional Court has recently decided the ADO 59, addressing environmental issues, particularly concerning the protection of the Amazon rainforest and the air quality standards. The actions argues that the government is not taking sufficient measures to reduce greenhouse gas emissions and mitigate the impact of climate change, which violates constitutional principles and international agreements assumed by the country. The authors reported the increase in deforestation in the legal Amazon region. The authors highlighted the importance of the Amazon Fund, emphasizing its creation and main objective to finance projects that combat deforestation and promote the conservation and sustainable use of natural resources in legal Amazon, including alternative land use. The Amazon Fund is considered a pioneer initiative in financing the Red Plus concept. The central opinion in this trial was conducted by Justice Rosa Weber, with an eminent climate focus. The justice emphasized that the case focuses on inconstitutionality by omission, which means that it contests the government inaction. The Brazilian government duties are especially important when it comes to benefit rights, such as social and environmental rights, and they require both normative and practical actions for their realization. The first paragraph of the Article 5 of the Brazilian Constitution requires the executive to create the necessary conditions to make these rights effective through regulations and concrete measures. The Justice Rosa Weber stressed that the state's role in fulfilling these duties has a margin of freedom, but this freedom must be aligned with the greater duty of protecting fundamental rights. The protection itself is not discretionary, but the forms of implementation can be flexible as long as they respect the principle of proportionality in relation to fundamental rights. This case, with a mainly climate focus, have given a very effective result. An example comes from the case Connects Human Rights Institutes versus the Brazilian Development Bank, BNDES in Portuguese, arguing that there is no possible of a financing project that does not respect the Paris Act. Before a final resolution of the case is open, the Brazilian Central Banks reformulate the public and private financing law and standards to adapt in the Brazil process of mitigation and adaptation. The great legacy of these three actions for Brazilian climate law was the direct recognized by the Brazilian Supreme Court that the intergenerational protection during terms of climate change is based on the Article 224 in the 225 in the Federal Constitution. Brazilian courts have been recognizing the tese this case climate is a legal asset with constitutional and autonomous status. They have been drawing up international jurisprudence, such as Urgenda and Bauer case, to support international climate law principles, which reflect the judiciary's commitment to environmental protection and the preservation of natural resources for future generations. The main point I wanted to share is about the opinion issued by Justice Carmen Lucia in IDPF 760 refers to Brazil as an ecological constitutional state, emphasizing that the protection of the environment is a matter of planetary scope, and that is the duty of state and society to ensure the ecological balance for present and future generations. In his opinion, as a core element of contemporary constitutionalism, recognize in the climate case the dignity of the human person, but also the dignity of all species and the preservation of the environmental as a whole. A balanced environmental and the interdependence of those rights with other human rights and all the human and species rights. The Brazilian Supreme Court, for all its vote, is very propense to adopt the concept of ecological democracy. That is, the democracy that survives and lets survive life and future generations. That will be a point I've said too much. Now, Rafaela will talk about the transitions in Brazil. Thank you.
Thank you. Well, good morning, everyone. Thank you, Luciana. Thank you all. I will share my screen and you talk to me if you see correctly right now. There is. It's okay, Dina? Yeah?
Yep,
okay.
we see it.
Oh, okay. So, good afternoon, dear all. As Luciana just commented, it's a joy to be with you and sharing a little about the evolution of climate litigation in Brazil. So the advances that these judgments just reported by Luciana, and to think together about future perspectives based on what has already been consolidated, especially in recent years, especially in the last year by the Supreme Court. And so Luciana discussed how decisions in cases help to build this climate rule of law, this intergenerational protection of the climate system. And I will continue exactly about this point and detailing how we can enable legal mechanisms that ensure that this standard can be and can provide conditions of the most important aspect, effectiveness in each case, in each lawsuit involving confronting climate change, even with lesser or greater repercussion on the topic. And I will briefly introduce myself to the group. Luciana already did this, and so explain the evolution of presentation and the topics that I choose to cover well. I am Rafaela Rosa. I'm Brazilian citizen. I'm born in Brazil. I live here, and I am federal judge since 2006. I'm also a PhD in law or doctorate in law from a Brazilian university, Unisinos. I'm visiting researcher at UC California Berkeley Law, and my sponsor there was Professor Daniel Farber. And I am currently assistant on the permanent committee of the SDG agenda on the National Council of Justice in Brazil, is a part of the judiciary power in Brazil. So I divided my presentation in two parts. First, and more briefly, I will explain some important premises that all of you must have in mind, that everyone can understand. One of the main mechanisms for implementing human rights agenda by the Brazilian judiciary, and including confronting climate change. And this refers to a choice made by the Brazilian judiciary to internalize the United Nations 2030 agenda, why we did this. And so next, I will explain that there is a commission in the National Council of Justice, and this commission was created to monitor the implementation, the compliance with the agenda by the judiciary power, by the Brazilian judiciary. And this is the commission that I work for at the moment. And in the conclusion of this first part, I will detail that one of the tasks of this agenda committee is to monitor the judges' compliance with resolutions and recommendations made by the National Council on main themes, on the themes of the agenda objectives and goals. So then I will choose and will specify with one resolution in particular, is the resolution 433. This resolution was made in 2021, and I will explain why this resolution is like a milestone for environmental law and for climate change law, the fundamental importance that this resolution has in the following path and direction on climate litigation in Brazil. And I will try to explain the main reasons for this. And so after that, in the second part of the presentation, I will detail this resolution, and because of the time, so this resolution has many aspects, but I will center in two aspects that we are in this committee, in this working group, currently working on. And the first one is point out is the use of satellite images and as means as evidence for judges in all environmental cases. And the other one, and more important, is the duty provided by this resolution in this Article 14, that all judges in Brazil must consider in their decisions, provisional or definitive decisions on environmental cases, the impact of conduct assessed by the case on global climate change. So this provision on the resolution made by the National Council of Justice in Brazil, I really believe that lies the foundations for the discussion on specific climate damage as a section, type, or dimension as of environmental damage. And this will certainly have some important impact in climate litigation going forward. So I will start with part one. And regarding the internalization of the 2030 agenda by the Brazilian judiciary, it is important to highlight first of all, the Brazilian judiciary was the first in the world to do this. And by accessing all these links that I will leave on the slides, you can also follow the history of this movement, how there is now an expression recognition of our judiciary, of the connection between the goals and objectives of the SDG agenda and human rights. But I would like to emphasize about this topic is that this reading made by the Brazilian judiciary, that the objectives of the agenda are aligned with the human rights protection system also provided by the Federal Constitution of Brazil. And that is the judiciary responsibility also to seek to achieve these objectives, to comply with the agenda. And this make the agenda not just like soft law in Brazil, but the goals and the objectives that the agenda provides is like a constitutional, there is constitutional status in Brazil. Brazil Federal Constitution, Luciana also mentioned that this point has more than 30 years ago provided the right to present and future generations to a healthy and balanced environment. The decision made just last year by the United Nations to recognize the human right to a healthy environment in Brazil has been such a reality in our law system, in the legal system since 40 years ago, since the National Environmental Policy made in 81. And so, but there is an importance, the importance of internalizing the agenda is that the detail that's goals and objectives reinforce the need to implement the rights that still make a healthy environment possible, such as the objective of taking climate change as well as the objective of promoting the energy transition. The Brazilian judiciary recognizes this objective as paths that fulfill the right to a healthy environment provided by the Federal Constitution. So, and how we can see this if you browse the websites of the Brazilian Supreme Court, as well as the website of the Superior Court of Justice, our second highest court, all of you will observe that all the legal cases, all the actions that are being processed in these courts, decided or not, are classified by the Sustainable Development Objectives. And all the discussions put in the case involved. And this is why we did this way, because this is the way we can monitor the level of judicialization regarding each one of the objectives, but also we can be able to develop statistics about these cases, decisions pro and against the cases. And for example, in the left sides of the slides, we have just the cases that Luciana mentioned, the climate fund cases and the Amazon fund case. And they are both classified according the objectives by the agenda. And I also want to mention that just yesterday, this is a brand new publication made by Supreme Court of Brazil. And this is the link that all of you can check it out, but it's a publication about resume environmental law decisions in the Supreme. And the Supreme Court also nominate this publication like a contemporary Supreme Court. And all of the cases, the most important environmental cases decided in the last few years, they provide in this publication. So obviously, I recommend it to read. And one example in the right side is just this ADPF 708, and you can check it out. All of the SDGs related to the cases are mentioned in this publication, because that is the way they are classified right now. And the same way happens to the Superior Court of Justice, and all the cases are categorized by the goals of the 2030 agenda, not just environmental cases, but cases related to access to clean water, to gender equality. All the cases are in this way. So in the National Council of Justice, there is many commissions and committees, and there is one commission. It was created in 2019, and this commission is not a temporary one, it's a permanent one. And this commission works with to monitor in the SDG agenda, and I work on this commission at the moment. And why is this? Why is monitoring? Why the duties of the Commission 2030 agenda on the National Council? There are many activities, many responsibilities, but I want to emphasize and highlight the competence to monitor the implementation of resolutions and recommendations about the agenda. Why is that? The National Council of Justice in Brazil approve resolutions and recommendations, and these resolutions and recommendations have some kind of normative force for us, for Brazilian judges, or which means we must comply. They must comply, and the commissions, the work commission monitors whether they are complying and how they can improve compliance with this. And I just want to take one example because it's an important example. In the last year, the National Council of Justice issued this recommendation, the 123 recommendation, and recommending all Brazilian judges to observe international human rights treaties and convention and use the jurisprudence or the decisions made provided by the Inter-American Court of Human Rights. And the commissions where I work can, for example, now we are awaiting the results of the advisory opinion, advisory opinion made on climate emergency and human rights, to after that can monitor the judge's compliance with recommendation. So, and I want to emphasize one particular resolution made by the National Council of Justice in 2021, because this resolution, I really believe it's like a milestone in environmental policy of the Brazilian judiciary. In this link, we can check it out. Has many articles, many programs, and many relevant aspects. And in the time of the presentation, I will only be able to explore two of them, but it's too important. For example, in the Article 1 of this resolution, there is express determination to all judges in Brazil must respect the Convention 169, which means free, prior, and informed consultation. And it's one of the aspects of this resolution in the first article. Also, Article 3 of this resolution created the sub-subject of climate litigation, climate case, in our unified procedural tables, and as a subject, a sub-subject of environmental law. The 2 points, the articles that I want to explore in the second part is the Article 11 and also the Article 14. The Article 11 is the authorization for judges in Brazil to use satellite images in decisions on environmental cases, environmental lawsuits. This is the article. Judges can consider the evidence produced by exclusively, and the articles say this, exclusively by remote sensing or obtained by satellites in the evidence collection on environmental cases. And why this provision? Well, in Brazil, it's a continental country. There are areas that are difficult to access in the field. We must take precautionaries. We have precautionaries to inspection structures, to inspect this place, even in the judicial system, even in the justice system. And the main goals of this article is to, for example, cease deforestation and burning activities that are in progress. We can now working on use predictions, ER prediction, to avoid the consummation of new forest cleanings and new forest fires, and also important to repair damage that already done. Luciana emphasized, I just want to re-emphasize, because the importance of reducing deforestation for Brazil meeting his emission mitigation targets. We lost in Pan-Amazonia, it's just not Brazil, but other countries, but we lost only in 35 years, we lost almost 10% of our native vegetation, and Brazil is responsible for close to 2/3 of emissions related to deforestation. This is a study provided by Map Biomas, and I also recommended the read. It is in English, so you all of you can check it out. The National Council of Justice in the last year, in the beginning of the year, have received 2 studies that unfortunately point out our less effectiveness of judicial cases and action in matters of deforestation. And one of them is study provided by Amazon. All of the studies is in the link below. You all can check it out. But this study selected one task force made by the Federal Public Prosecution in Brazil. And this program launched by the Federal Public Prosecution it's called the Amazon Protege program, the Amazon Protects. And they intend to hold illegal deforestation liable for environmental damage and true cases. And one of the innovations of this program is the try to confirmation of deforestation and deforested identities by crossing 2 principal pieces of information: use of satellite images to indicate where is the environmental damage, and cross with public databases who naming those responsible for these areas. But the main findings of this research, unfortunately, is that some judges in Brazil, both federal and court judges, state judges, still stated that satellite images were insufficient to prove environmental damage, and that like a field inspection would be necessary. However, rulings from the second instance court and Superior Court also overturned some of these decisions. And so because of that, the punishment of illegal deforestation, in first instance was limited. And most of the judges rejected the reports based on satellite images and without final inspections. And so another research in the beginning of this year, 2023, was commissioned by the National Council and was provided by this foundation, Getúlio Vargas Foundation in Brazil. And in June 2023, this research was presented for us, and this research was called the Empirical Studies of Effectiveness on Environmental Jurisdiction in the Legal Amazon. And unfortunately, also this research reinforcing the data provided by Amazon that we are improving the perception of judges to the potential use of satellite images and georeferencing, but endorsing the Amazon diagnosis. Also, this research highlighted that there is some obstacles to implementation of new technology, and we need to provide some acculturation of the legal operators of these tools, the importance of associations, the use of technology, and legal and procedural care to validating these elements. And the main findings of this research is the need for training judges, training members of the judiciary branch to the best use of this potential use of technologies tools, such as satellite and georeference, and reinforcing the improving communication about these precedents in the first and second instance. So after receiving these two studies, what the National Council of Justice decided to do in July, just in July of this year, we created an interinstitutional working group. This group is made by federal and state judges from all regions in Brazil. We have 2 members of the public minister, one from federal, one from state. We have the public advocacy of the union as part of the group. We have the council of the Brazilian Bar Association, and also researchers from Federal University in the state of Mato Grosso. We are a total of 15 members and a coordinate counselor. And this is in the picture is this part of this working group. This composition, interinstitutional, we understand that it's important to achieve as fast as we can a consensus among all institutions that work on the topic in the judicial system to avoid conflicts over procedures defined by the working group. And so what we do until now, our first delivery is just made by now. In September, this month, we deliver a protocol for using satellite images or focus on Article 11. What it is this protocol? We explain basic concepts about remote sensing in a glossary. We summarize all satellite systems that are in use for free or by payments in Brazil, and also emphasize their reliability, their confidence, and technical precision. Some of them is in the images in the right side. And we explain in this protocol the procedural precautions necessary for the judges to use this evidence, both in civil cases, in civil actions, and also in cases regarding environmental crimes. And we consolidate cases and jurisprudence in Brazil provided by higher courts that endorse and reinforce the reliability of the use of satellite images. And such example, this decision made in Amazon phone case. And we made some final protocol suggestions, and we after the adoption of the protocol, the current state of judicialization related to use of images in the collection of environmental cases will be monitored by the National Council, so that we can counterpoint can be made with the state in the future after time, and training of the judiciary on the content of the protocol. And in compliance with another provisions, another articles in this resolution 433, we request to all judicial schools in Brazil and magistrate schools in Brazil to mandatory incorporate the term of use of remote sensing images in the evidence base on environmental cases, and training courses to offer civil servants and magistrates and judges working in judicial cases, in judicial units with environmental criminal jurisdictions. And one example of judges schools that want to be compliant with the protocol is the federal court where I work on, is the federal court for 4 regions, is the South states in Brazil, and will hold now in September, in next 27, 28, and 29 of this month, September, we will hold the first course on climate change law. And I am the scientific coordination of this of the course. And in the program, to comply just with the protocol, with the working group protocol to the National Council, and also to serve like as a model to be replicated by other judges schools. We planned a class to teach the use of satellite image and identify deforestation, burning, and other environmental offenses. And I also invited everyone because the entire course will be broadcasted in the YouTube channel of the School of Judges for the Federal Court of the Four Region. So, and to close to the end, in the end, finding part. The next step, and probably more important than this one, is the Article 14, first part, the resolution, the same resolution, 433. What these articles say? Well, when sentencing, when deciding cases on environmental damage, the judge must consider, among other parameters, the impact of this damage on global climate change. And other questions, other parameters, diffuse damage that affect people and communities, and also consider the deterrent effect on externalities. So this article in the first part is like a express recognition of another species of environmental damage, one particular one dimension, the climate damage, and is recognized in Brazil. We made last year a public consultation about this issue, and when we open also the National Council, when we open this consultation, we express his fears that all of decisions in environmental matters in Brazil must use and must be guided by appropriate scientific criteria, and we express such as the science of attribution on climate and on environmental litigation. And after that, and this year, to make like to can access like what kind of methodology we can use to calculate the climate damage. We made just in July, and this is in the material when we invitation for this panel, a public hearing in July in the National Council of Justice, and our working group asked to Brazilian specialists about the potential use of metrics based on greenhouse gas emissions or suppression of skin holes per area, per hectare, affected by harmful conduct, and type of use of instruments such as voluntary carbon market or social cost of carbon, and their adequacy for the Brazilian reality. And at this point, the working group will focus on provide for the Brazilian judges some methodology to calculate this. And particular for me is like it is a special recognition that we have some climate damage. Climate damage is different. It's like a species, is a dimension of environmental damage. Is this also the theme of my book and the theme of my thesis is because in Brazil, the responsibility for environmental damage is objective in our legal system, and the damage or risk of damage and just the causal link are sufficient to decide it to put responsibility. So climate damage is a damage to the climate system. It's a global damage, it's a transnational damage. We have just one climate system, but it's possible. It's possible to hold individuals for this damage to the climate system based on the science of attribution, and specific the science of emission source. So direct and indirect agents are responsible as polluters under the Brazilian law, and including governments who fail to, and also agents that financing polluting activities. And the methodology for calculating climate damage is still building, is building in the working group, but we have some contributions by this hearing. And when we valuing climate damage, for example, due to deforestation, there is a need to consider and estimate the carbon stock containing in the deforestation area. And obviously, this estimate depends on both the species of vegetation affected, which biome it is, what is the physiognomy of this vegetation, and also the density of the forest. And this is first part. And in addition to estimate the stocks of carbon in the Brazilian biomes, after that, we need to put a price, carbon to be priced. And based on such information, deforestation area, average of carbon stock and carbon price, it would be possible to calculate, to estimate the value of climate damage. And there are two steps, a quantification of carbon emitted by the harmful conduct, as example, deforestation or burning areas, and the area and the carbon price. And this is now happens. Is happen in new climate cases in Brazil. Just is a brand new case. And it is a very important one because it's just 2 days ago, a new litigation, the Federal Public Prosecutor's Office in Brazil charges in the 292 million Brazilian reals, which is almost $16 million from just one environmental offender. And this case involves climate damage, specific climate damage for greenhouse emissions that result in its consequence of deforestation. This case was proposed just Tuesday, and I put the link below that anyone can access the all information about the case. And this initial petition on the case refers this climate damage. And one of the final requests of the action is that the case be sent to us, to the National Council of Justice, to inform this present demand in order to integrate this process with the referential basis of repair that we are working on in the working group formed by the Council. So, and to sum up and finalize, I talk too much, but if you ask to me, climate litigation will increase in Brazil? Yes, probably. And why? One of the reasons we just see the kind of fragility of this Belém Charter made in the Amazon Summit. The Belém Charter was signed just 1 month ago in August 2023. All Amazon countries agreed to seek and prevent the collapse of the Amazon forest, but there is it's true, there is no consensus on how to achieve this. And so the Belém Charter letter, well, disappointed us because not setting zero deforestation goals and targets, and also not definitely condemning the advance of such as fossil fuel exploration in the region. There is no consensus on something like a fossil fuel non-proliferation zone. So it is very likely that litigation will increase and probably to demand compliance with climate laws that and already in force in these countries, such as Brazil, and also to compliance with judicial precedents, such as all the cases mentioned by Luciana. So I want to thank you all, and any questions, suggestion, I put on the last slide the both emails, Luciana email and also my email. Feel free to ask for us. So I wanted to, it's to you, Dina, and thank you all.
Thank you. Thank you so much, Rafaela, and thank you so much, Luciana. Those were fascinating talks. And it really is incredible to hear what a kind of, I mean, I think we all are kind of aware of what a progressive home of climate litigation the Brazilian court is, but even I didn't have a kind of full sense of it, or a sense of some of the things that were happening around judicial training and some of the issues around evidence use. So that was fascinating. Thank you. I saw there was one question in the chat, which maybe Luciana already answered, about how courts can gather evidence, whether they can gather their own evidence or whether they can commission satellite image evidence of their own. Did you want to say anything else about that, or is that question answered?
Is the question made by Hay? That is,
Yes.
Can courts also commission satellite images evidence, or does needs to be submitted by a party? It's a good question, Hay. First, prior, the parts who introduced some cases, public ministry or social organizations made provide to the judges this image systems. Also, for example, Produce, Deter, or PlanetScope provided by NASA and now is used by federal policy in Brazil, and probably is the best satellite images now in operation, not just in Brazil, but all over the world, this PlanetScope system. But until now, we judges don't have this permission to choose which one we want to use, or just use the better one. In this protocol, we emphasize that all of the systems are reliable, we can use, and it's up to the parts to choose specifically one of them. But at the same time, the National Council of Justice, and there is a National Council of Public Ministry, is the same, works in the same way. And we want to establish like a former agreement that the National Council of Public Ministry agreed to use the better satellite systems. And if they do this, probably 19% of the actions will become with the best satellite system. We are working on this because we now can study all of these satellite image systems that is the same time available, but there is a difference in quality, in precisions. And for example, I can speak about the PlanetScope system used by the federal policy in Brazil. It's better precision. This spatial, we call spatial resolution, the time of images, and this PlanetScope is diary. Every day there are pictures to the same place. It's the only one that provides diary images. So answer to your question, the judges can't decide whatever they want to use, but we are working to the National Council of the Public Ministry to agree to use or to prioritize the use of the best system available. So.
Thank you, and thanks for that question. Are there any questions from I have a couple of questions, but before I abuse my platform, are there any questions from anyone else in the audience?
I do have one.
Go for it, Mariana.
All right. So this question is to both of you, but I think it was Luciana who spoke about it. So you mentioned the ADPF 708, the case, and did I get that right, that it was also considered, I don't know if the word unconstitutional is the right one, but that it was also like sort of prohibited because there were funds of other countries involved, or money of other countries involved in this fund? Did I read that right? I'm sorry if not.
Luciana, tu quer que eu fale alguma coisa sobre isso, Lu? Posso falar?
I think we've actually just lost Luciana. Maybe she's having some internet.
Okay. So, Manuela, can I can
Yes, please.
say something about the case, because this case, it's about the climate fund, and actually the climate fund is like a fund, a public fund, and in other countries such as Norway, for example, yes, put some money in this fund. And this money, this fund was blocked by the last federal government in Brazil. Was no operational exist, but no movement in the fund. And one of main discussions in this case is just the climate fund must be operational all the time, must work and must function. It's not a political choice. It's like to comply with the Federal Constitution of Brazil is one of the main achievements of the decision. And so you are correct. Other countries put money in. Norway, I believe, is the country who puts more money in the climate fund.
Okay, obrigada.
Thanks, Manuela. Any other questions? I mean, one of the things that I think was really interesting about your talk, Rafaela, was, and it's come up kind of a little bit in a few of the panels in the summer school, was this issue of the kind of role of science in legal decision-making and in judicial decision-making. And one of the things that you point to is kind of judicial misunderstanding or distrust of certain kind of science. So you're talking about how judges didn't want to use the satellite images and needed to do the training. Are you seeing kind of an evolution? Is there sort of increasing, because the science keeps getting more complicated in various ways, you know, it's not just about measuring damage, but what that means is that, sorry, go ahead.
No, it's okay. Yes, I can see a slow evolution, but slow in translate all these scientific concepts input in the cases and in judicial decisions. If you all of you read this decision made by Supreme Court last year, the ADPF 708, in the vote of the Justice Faquin, for the first time, he beginning the vote, he refers to the IPCC-RRC's report. And he fears the main conclusions. He fears the working group number one. He fears this is an established fact, mitigation is needed, and it's a big step for it because it's a justice in the Supreme Court, and he started the vote. He expressly feared the main in the IPCC report. So it's slow, but it is a revolution. And why I say so, I believe this year and the next year, because of this working group, also because of this working group and this protocol that's demanding all school training judges, not training judges about environmental issues in general, about principles that we are already know and already study, but specifically form judges in climate change law, in climate science. And I really believe now, this month, in my federal court, we will deliver a 3-day course, an immersive course. And the first panel is provided by an IPCC scientist, one of the Nobel Prize IPCC scientists. And I say to him, talk like the basis. What is greenhouse gas? Which is greenhouse gases? What is IPCC? What is so? I believe there is some improvement, yes, and I hope to be able to working on this. Yeah, I am working on this actually.
Thank you. Go ahead, Manuela.
That reminds me, I still have a question actually about this. You said, so there was like a public poll or before the public hearing, there was something like a public participation, right? Was that open to basically everyone? So everyone could participate in?
Yeah,
oh, wow,
everyone. We made last year, the National Council of Justice in Brazil made last year, 2022, a public consultation. And in the website of the National Council was available. We want to hear everyone. And was publishing in Portuguese, was publishing in English also. We want to hear everyone about these topics. Please provide us satellite images are reliable, which ones it is, and also provide us with information about what kind of measures we can use, what kind of methodologies we can use to measure the impact of environmental damage in thinking about emissions or carbon sinks. We made this last year, and this year we made a public hearing. I see Maria Antonia here. Maria Antonia was invited to this public hearing. We invited some specialists, but also besides invite these invitations, all who wants to participate can access and talk about like 10, 15 minutes choose. We made like questions before and are public questions. You can choose one to answer a specific point. Oh, I have some expertise in this point, so I will go there and talk. And all this public hearing, there is available. It is in YouTube, and if you see, there is more than 100,000 people just right now to watch this public hearing. So we know there is a big step for it to have to make this public hearing, and now we are working on improvement these articles of the resolution, because there is we have very good material to working on. Yeah.
And I just have a quick follow-up question. So for the public participation, did you have a lot of participants? Did a lot of people give their opinion?
We expect more, Manuela, because we published it, we announcement, we invited, but we reserve one full day starting 9 a.m. and finish 6 p.m. I guess, and full day. Who wants to talk? Go there and talk. We listen by online or in person, and there is. I can't see. I can't say the exactly number of participants, but all day long, people are there and talk about. So was good.
Can I maybe ask, connected to that, is how? Sorry, there's a question in the chat. Maybe we should look at that. Maria Antonia says, not sure if this was covered before, but could you talk a little bit about the prospects of climate litigation, considering the change in Brazil's presidency, since so many cases were brought during the Bolsonaro administration? That's a great question.
Yes, sure. And probably we will see a change in the climate litigation in the last 4 years. Most of all before are presenting against the federal government, against decisions, against the climate fund case, the Amazon case, and these precedents discussed by Luciana was, many of them was they starting with public parties and against the federal government. And now I really believe there is a big difference. First of all, the federal government is complying, wants to reduce deforestation. It's believe in climate science, believe in climate change. It's very different. And so, but even believing in climate change, in climate emergency, actually, there are many decisions and important decisions, and not about deforestation. Deforestation is falling in Brazil. It's really falling in the Amazon region, not in the bioma Cerrado, but in the Amazon region is falling. But there is other decisions like the prospect of exploring offshore fossil fuels like petroleum in the Amazon equatorial, this region. And probably that we can see political choices not aligned with the Paris Agreement. Once this discussion, I believe, we still have cases against the federal government, against subnational governments, because we have now this, it's like a contradiction, because we believe, but we're still doing these decisions in other points. And at the same time, I really believe that climate cases against private agents will be much more intense in Brazil. We are experimenting climate weather events, extreme climate weather events like never before. I live in the south state of Brazil, and we are flooding like it's like 3 times this year. Just this week, people are dying like in numbers that never seen before. And I really believe that some cases will be brought, in climate cases, of course, against private agents, and using science attribution to connect their contribution in their meaning contribution in the climate damage and the loss and damages. So I believe that we probably increase climate cases, not against public agents, but particularly against private agents, not just to climate weather events, but also to demanding their compliance with Paris Agreement, such as the case against the Royal Dutch Shell. I believe we will see cases like this one, like the middle defense case. We will see some, and I hope the judges are well prepared for. Yeah, I'm working on this.
That was actually going to be my question, was going to be about what the prospects were for private parties being litigated against in the Brazilian courts, and whether there are barriers, I guess, in Brazilian law to successfully bringing cases against corporations rather than the state.
Actually, Gina, I don't believe there is some barriers because we have, again, to pursue responsibility for private agents. One of the slides, I emphasize that we have a microsystem to responsibility, like a tort law system just for environmental cases, environmental damage. Is different. I don't see in any part of the world just like this one. It's like we have some microsystem to everyone can be responsible for environmental damage. And when we understand the climate damage is like a species of dimensions on environmental damage as a general, the microsystem, the legal microsystem, in Brazil about responsibility for this damage includes, and also the jurisprudence in higher courts, in Superior Court and Supreme Court, also emphasize this responsibility is objective, which means it's not important full of service. It's objective. We can put and we can demand. It's a choice made by parts. If you demand a public agent, a private agent, everyone could be understanding like a polluter. So this is the microsystem works on. And even the the private agents who financing, who like such a banks and pension funds, even those are probably could be polluters in our legal system about responsibility for environmental damage. So I didn't see, I don't see there is some barriers in our legal system, procedure, or even jurisprudence. What happens until now? The last 4 years, most of the cases were against federal government because the federal government don't believe in climate change. To sum up, to resume, but for now on, it's different, and it's different, and probably the social organizations, probably the public ministry, will be more interested, and will be more focused on what the private agents are doing or not doing to align, to comply with Paris Agreement. I believe so, and we will see. But my impression is that.
Thank you. Luciana, I can see you're back with us. I don't know if you heard all of that, but I was wondering whether you wanted to come in and add anything to this discussion at this point.
So sorry, I have a problem with my internet. I think the climate litigation moved to the government, to the private subjects, like the Connectas case. And there are most problem with the assurance in Brazil and the assurance law and climate change.
Yeah, it's true. Yeah, Luciana pointed out another great point. Insurance and private agents, and both public insurance and private insurance, we can see now this judicialization is growing up, because many, such an example, laws of safras, I don't know the correct expression for this, but loss of agricultural areas because of extreme weather events, and the insurance companies are denying because, oh, it's not well. And so these cases are growing up, and also about flooding cases. So it's against private agents also.
Really interesting. The insurance issue. I think that's going to be a global
problem.
Yeah.
We have at this moment, we are not just like US, for example, or such as states like Florida and California. Insurance companies are runaway, are just denying insurance. We are not at this point at the moment. In Brazil, insurance companies are still given insurance, but they are denying when climate weather events happens to provide it. And so these are the cases at the moment. But I really believe in the next few years, the same movement like happens in Florida and California, for example, happens here in Brazil. The insurance companies simply run away.
Yeah.
Unfortunately, yeah.
Yeah. I still have 2 questions, but I don't take up all our time.
It's okay. No, for me, it's okay. It's a pleasure. It's a pleasure. This moment, it's a good moment to talk. Yeah.
Well, maybe I'll just put them both to you, and you can choose. So one of my questions is about the kind of accessibility of the court and climate litigation in the future, and what the sort of issues will be around access and participation by Indigenous peoples, and the kind of I was also thinking about it in relation to courts' engagement with science, but also kind of Indigenous expertise, how courts are sort of responding to integrating, dealing with Indigenous knowledge in their reasoning. And then the other question I had, which is a completely unrelated question, was about the extent to which there has been cross a transnational judicial sharing and discussion between the Brazilian judges and courts and courts in other jurisdictions, and whether you think there'll be a lot more of that in the future, or whether Brazil's seen as a bit of a kind of outlier.
Yeah, for the both questions, Gina, I am optimist. I am hope about the very good movements. First of all, to acknowledge or recognizing or integrate and incorporate indigenous acknowledges indigenous solutions, indigenous in this conversation. This year, just last month, the Supreme Court launched the Brazilian Constitution in indigenous languages and published it. And so it's like we have at this moment many initiatives and to do exactly what you are asking for, to integrate language, knowledges, and so probably we will see more cases provided, or parts of the cases to begin in the cases, indigenous people in climate cases also. And for the other part, the judicial perception or judicial one probably will be more perceptible, more to put this all this technology in the conversation. I am very hopeful about this movement because we can see it is happening. And also about such a thing like transjudicialism, to use the expression. Yes, Brazilian judges, Supreme Court, lower courts are very open to use decisions, use cases already decided, not just in environmental matters or not just in climate matters, but also in many aspects, in many human rights aspects. And so I really believe this movement is happening. And when we see these decisions provided by Supreme Court last year, this who Luciana talked about, in most of them, cases such as Urgenda, such as Colombia against future generations against Colombia, such as, I don't know, but many cases, probably, no, Bauer cases, the German one was mentioned. And even in Superior Court, the second highest court in Brazil, the Superior Court of Justice, you can see in many cases, even when are not climate cases specifically, are general environmental cases, these cases are cited, are used. So I really believe this movement is growing and is part of this resolution 433, training judges, informing judges in these issues. And one part is obviously to, for example, in another country, they decide this. In another country, they decide that. Bring these examples to the room. And just to finish, in this platform, this Just Clima platform, one choose the group made was exactly this. Each Brazilian case, we choose another case in another country who decide the same question, like, well, we must stop a new coal mining, underground coal mining, here in my state. There is some case like this one colleague, one federal judges just decide last year, yes, because all evaluation just forget the climate impacts, and we put the case. And when we put the case in this platform, we provide like an Australian case by Brian Preston, the Gloucester case, and all. It's the same discussions, it's the same arguments. It's, you can use if you want, you can check it out if you want. So I believe the hope in the both issues of your questions. Yeah.
Fantastic, thank you. I see a comment about what an amazing discussion this has been. I agree, but I don't see any other questions at this point. Any other thoughts or questions from anyone? In that case, oh, there is.
But it's
Oh, it's
Luciana.
coming from Luciana.
Yeah. Oh yes, she remembered a very important case. Yeah. We believe this case will be delivered and the final decision this year. It's about the temporal market. It's like a complex discussion. I don't know if I can summarize, but there is some discussions. One point of view say the federal constitution in Brazil, it's 88, it's almost 30 years. And in the federal constitution, there is some article that is indigenous lands are original lands that belongs to indigenous people. And the interpretation of this article, we have two possible interpretations. If people are there in 88, if indigenous people are in this land in 88, or no matter if people are there in 88 or are fighting to recover this land in 1988, these lands belong to indigenous people. So the Supreme Court must decide, and probably we will decide this year about this issue. We have some votes right now, just a few votes by judges, by some justice in Supreme Court. But, well, it's probably another milestone because if the Supreme Court decided, no matter what, in 88, indigenous lands belong to indigenous people, even if they are there or are fighting to get back there because they are exposed from there, it's one option. And my personal opinion is just my personal opinion. It's gonna be the final decision in this way. But another possibility is to recognize if the indigenous people wasn't there in 88, no matter what reason, so this land can be no more indigenous land. So 33% of the Brazilian territory is indigenous land, 33%. So it's a big issue. And thank you, Luciana, for remembering this case. Yeah.
Yeah, fascinating.
Considering that indigenous lands are the most preserved in terms of biomes, I view this action as a climate-related initiative with a climate-focused background.
Yeah. There isn't some like implicit climate discussions there. It's not explicitly, but of course, all indigenous land is like Luciana say, it's more, our areas more with more conservative initiatives. And so a lot of things happened this year.
Yeah, amazing. That sounds like it's going to be an incredibly fascinating, important case. Thank you. I think we're out of time. This has been a wonderful discussion. It's been incredible to hear more about the decisions that have been made in the Brazilian court, about the training that's happening, and about some of your projections for the future and what's going to come next. It's really been wonderful. So thank you so much, Rafaela. Thank you, Luciana. We really have loved having you in our summer school. I'd really appreciate you being here. Don't go far away. We have 2 more panels today, both of them looking at aspects of the ocean, including a panel that Alana, who's in the audience, is going to be part of. So please don't go far. Make a cup of tea and come back and join us for the next one. But again, a very warm thank you to Rafaela and Luciana. Bye, everyone. See you soon.
Bye. Thank you all.
Thank you.
Bye.